Hey everyone, Harry here to talk about strike one for Donald Trump in his frenetic, even desperate effort to get his sentencing scheduled for this Friday in the courtroom of Justice Juan Merchan, where he was convicted by a jury of 34 felony counts somehow to go away. So recall what Merchan has done. He has denied Trump's motions for a new trial based on immunity and then said it's time for sentencing. That's what happens to a criminal defendant. And that, in fact, under New York law, is the act that makes a conviction final. It can still be appealed after a sentence. You can try to say the trial was flawed in different ways or whatever. But first, sentencing. And that's what will make this sort of a historical fact and brand Trump with the scarlet letter that identifies him uniquely among American presidents as a felon. So Merchan wisely, I think, said, we'll make it an unconditional discharge. You can do that under New York law. You can give a conditional discharge, go away, but you can't associate with this person, for example. Or there's a provision, unconditional discharge, just go on your way. I have no more control or power over you, not even probation. And Merchan, I think, adroitly analyzes that to give him anything that gives the court some power over him, Trump would have a very solid basis for wiping away once he becomes president because of the not quite established in law, but as part of a memorandum in the Department of Justice that is more or less taking on the force of law. You can't do anything to a sitting president. You can't make him come here or there. You can't prosecute. You can't take it on appeal. So Merchan knows that if he imposes any kind of conditions, Trump can maybe get things reversed. And then the conviction could go away. So Merchan, I think wisely and in a really important way for society, has his eye on the ball, the right ball, of making this a historical fact. Donald Trump, president slash felon. Now, that's what Trump is trying very hard to avoid any way he can. But to do that, he can't now try. There's just not enough time before the inauguration when everything would sort of freeze to get the decision on the merits or any claims on the trial reversed. He could bring those claims after his term ends, maybe even during his term, he could pursue an appeal by waiving his rights not to. That could happen. But until then, things will stay as they are if Merchan sentences on January 10th. And what we can expect is probably Trump to be in Florida. That's what his lawyers have said anyway. You know, you can never count out the possibility that he comes to New York and stages a media circus, but he's down in Florida. Merchan gets on the Zoom and basically chastises Trump and gives him the kind of stern lecture that you give convicts, which is what he would be, but then says, now you can go, you're unconditionally discharged. But history, society, the judicial system would record truly what happened, which is Trump was convicted. So he is trying anything he can to try to get out of it, and he's lost his first effort. Merchan, New York trial court. Above him, an appellate court, the appellate division. Above that, a supreme highest court, which is called the New York Court of Appeals. Above that, the U.S. Supreme Court. And Trump has a few days until sentencing, and you can bet he'll do anything and everything he can. But there was a hearing, a pretty short hearing this morning in the appellate division, and they came out just with a typed up form really saying the request for an emergency stay is denied. Boom. So that's now done. He can take that, and we should expect him to take it to the New York Court of Appeals, the highest court there, and make the same claim. At the same time, it's possible, theoretically, and I think we should also be prepared for a separate line in the federal courts, maybe beginning with the Second Circuit Court of Appeals, to try to make them put a kibosh on things based on federal supremacy doctrine and the notion that, as one of the arguments he's made to Mir Chan, I'm president. He's made basically two arguments. I'm immune under the Supreme Court immunity ruling. Mir Chan said, hey, no, you're not. This was private, unofficial conduct. Most of it was before you were even president, paying hush money to Stormy Daniels and falsifying records. And he's also said, you can't do anything to a president, and that extends to a president-elect. I think that's a pretty lousy argument. There's only one president at a time in the country, and that's not Donald Trump, and won't be Donald Trump until noon of January 20th. But he can try to float that argument in an emergency sort of extreme appeal in the Second Circuit, and that would be another channel to the U.S. Supreme Court. Basically, they're just, in his lawyers, who incidentally are the same. The main ones are going to be important figures and officials in the Department of Justice. And to the extent they're making really crappy arguments now, I think it affects their reputation that they're going to really need when they do begin to represent the federal government. But anyway, you can look to them to right away bring something to the New York highest court, and then maybe open another channel. And it will be some version of the argument. There's sort of two versions of the immunity argument. One is, I'm immune under the Supreme Court holding, and Mir Chan is wrong. Now, remember, they don't have to get a court to agree. They have to get a court to think that his prospects are strong enough and that it's worth granting a stay, and then that he might have irreparable injury. That normally wouldn't be the case for a convict. You get sentenced and the court makes an error. The Court of Appeals overturns it. But he's making some claim that, just having it pronounced will hobble him as a president, and that's irreparable injury. He's also saying they introduced, did the DA, evidence of immune conduct at trial. That is a few things, but especially a conversation he had with Hope Hicks in the Oval Office when the Wall Street Journal was going to break the Stormy Daniels story. Remember, the Supreme Court, in a really far-reaching aspect of its very far-reaching immunity opinion, said you can't even introduce evidence of immune conduct. And he's saying they did that. Now, Mir Chan has said, no, they didn't. There was nothing immune about this conversation about your unofficial conduct. But even if there was, that doesn't mean you get an automatic stay. You do get an automatic stay to press immunity itself, because immunity is a right not to be tried in the first place. But the introduction of the evidence already has happened. There's nothing, no right to try to protect anymore. You just reverse it if it's wrong. So, two parts to the immunity argument: immunity generally and immunity evidence. Those, I think, ought to fail. And then likewise, this notion that he's president-elect and that's somehow cloaked in the same rights a president would have. But you'll see some version of that, and thrown up against the wall of any court he can throw it up against, starting with the New York Court of Appeals. But look also, as I've said, to another channel. All of it's a frenetic race with a ticking clock, because he's got 72 hours a little bit less until he has to appear in Judge Merchan's courtroom by Zoom come Friday to hear sentence pronounced. So we'll follow his next moves. I'll be back to you to explain them. I don't think they should prevail, but it's such a crazy landscape, and especially the U.S. Supreme Court is unpredictable and has shown Trump favor before, so we have to hold our breath until they rule. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.